Hello and welcome to Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we've uploaded 10 MBE questions. We'll go through the questions. We'll fully analyze the correct as well as the incorrect answers and hopefully help you prepare for this bar exam that's coming up all too soon. Lesson 21. Question number 1. Driver negligently drove his car into pedestrian, breaking her leg. Pedestrian's leg was put in a cast, and she used crutches to get about. While shopping at Market, her local supermarket, pedestrian non-negligently placed one of her crutches on a banana peel and had been negligently left on the floor by the manager of Market's produce department. Pedestrian's crutch slipped on the peel and she fell to the floor, breaking her arm. Had pedestrian stepped on the banana peel at a time when she did not have to use crutches, she would have likely regained her balance. Pedestrian sued driver and Market for her injuries. Pedestrian will be able to recover from A. Driver for her broken leg only. B. Driver for both of her injuries. C. Market for both of her injuries. D. Driver for her broken leg only, and Market for her broken arm only. Take a few seconds, choose what you believe is the best answer, and let's see if you're right. Well, I hope you chose option B, driver for both of her injuries. To establish a prima facie case of negligence, the plaintiff must show a duty, a breach of that duty, causation, and damages. Causation includes both actual cause and proximate cause. Actual cause means that but for the breach of the duty by the defendant, the plaintiff would not have been injured. Proximate cause is the philosophical connection which limits liability to consequences that bear some reasonable relationship to the defendant's conduct, so as not to offend notions of common sense, justice, and logic. In this case, driver negligently drove his car into pedestrian. Do you know how we know this? Because the call of the question told us as such. Breaking her leg. So driver is clearly liable to pedestrian for the broken leg. That's obvious. Here's where we get a little bit more complex. Subsequently, while on crutches, pedestrian non-negligently placed one of her crutches on a banana peel that had been negligently left on the floor by the manager of Market's produce department, which caused pedestrian to slip and fall, breaking her arm. Since her broken leg was a substantial factor in the causing of her broken arm, and this injury was a foreseeable result of a pedestrian having to use crutches, driver is also liable to the pedestrian for the broken arm. It's important to note that Market would also be liable for pedestrian's broken arm under the theory of a thin skull or an eggshell doctrine. Plaintiff when a foreseeable victim suffers an unforeseeable extent of harm. So while B is the correct or the best response, don't forget the fact that the Market would theoretically still be liable for the arm as well. Let's look at options A, C, and D. Option A, driver for her broken leg only. Given the analysis we've just gone through, that would be incorrect because it's reasonably foreseeable that as a result of the crutches, as a result of the negligence and the injury caused by the negligence, that there could be subsequent injury or subsequent damage. C, Market for both of her injuries. This doesn't make sense. Market had nothing to do with the original car accident. So why would the Market be liable for the broken leg as a result of the car accident? C is one you should be able to eliminate right off the top of the bat. D, driver for her broken leg only, and Market for her broken arm only. While this is pretty close to accurate, this would be your second best option, right? It's a little bit tricky. If you didn't know the rule, you might have chosen D rather than B. But the issue here is the fact that ultimately driver could be liable for the broken arm as well, given the connection between the two, and given the fact that as a result of the injuries, the secondary fall was caused by the condition of the plaintiff. So as a result, B is the very best answer here. Question number 2. Loyal, age 60, who had no plans for early retirement, had worked for Mutate Inc. for 20 years as a managerial employee at will. When he had a conversation with the company's president, George Mutant, about Loyal's post-retirement goal of extensive travel around the United States. A month later, Mutant handed Loyal a written, signed resolution of the company's board of directors stating that when and if Loyal should decide to retire, at his option, the company, in recognition of his past service, would pay him a $2,000 per month lifetime pension. The company had no regularized retirement plan for at-will employees. Shortly thereafter, Loyal retired and immediately bought a $30,000 recreational vehicle for his planned travels. After receiving the promised $2,000 monthly pension from Mutate Inc. for 6 months, Loyal, now unemployable elsewhere, received a letter from Mutate Inc. advising him that the pension would cease immediately because of recessionary budgetary constraints, affecting in varying degrees all managerial salaries and retirement pensions. In a suit against Mutate Inc. for breach of contract, Loyal will probably A. win because he retired from the company as bargained for consideration for the board's promise to him of a lifetime pension. B. Win because his decision to retire and to buy the recreational vehicle in reasonable reliance of the board's promise to him of a lifetime pension. C. Lose because the board's promise to him of a lifetime pension was an unenforceable gift promise. Or D. Lose because he had an employee at will throughout his active service with the company. Take a few seconds and choose the best option now. The correct answer here is B. I hope you got that right. Win because he timed his decision to retire and to buy the RV in reasonable reliance on the board's promise to pay him a lifetime pension. Remember that as a general rule, something that happened before the promise cannot be consideration. Furthermore, when a person does something that nobody asked them to do, that cannot be considered consideration either. It can, however, be promissory estoppel or detrimental reliance. The elements required for promissory estoppel are words of a promise, reliance that is reasonable, detrimental, and foreseeable, and enforcement is necessary to avoid injustice. In this case, the company promised to pay the employee Loyal $2,000 a month in a lifetime pension in recognition of the past service. Generally, this promise would be unenforceable because Loyal's past employment cannot be consideration for anything in the future because it's already happened, because it occurred before the board's promise. However, in reliance of this promise, Loyal retired and immediately bought a $30,000 recreational vehicle. While nobody from the company asked Loyal to do any of these things, Loyal clearly took these steps in reliance of the company's promise. This reliance was reasonable, detrimental, and foreseeable. As such, Loyal will probably win a suit against Mutate Inc. because he timed his decision to retire and to buy the RV in reasonable reliance of the board's promise to him of a lifetime pension. Let's look at the other options. A. Win because he retired from the company as bargained for consideration for the board's promise to him of a lifetime pension. This is, in essence, the most incorrect answer that you could choose here. The reason for it is that, remember, the prior work and the prior commitment are not consideration for this new agreement. This is work that has already happened. This is, in essence, a gift. C. Lose because the board's promise to him of a lifetime pension was an unenforceable gift promise. Just like we did in the analysis of A, yes, it's close to a gift. That's beside the point. However, C is incorrect, more so because it ignores the fact that there was reliance on the promise. And more importantly, as we discussed, the reliance was in fact reasonable, detrimental, etc. D. Lose because he had been an employee at will throughout his active service with the company. Irrelevant. You shouldn't have chosen that one. Here, while at-will employment means you can be let go at any point, that's true and that's right, but that has nothing to do with our contracts question here. D is thrown in there as an absolute red herring and has, in essence, nothing to do with our call of the question. So I hope you chose option B. That would be your correct answer. Let's move on to Let's go on to question number 3. Doctor, a resident of the city of Greenville in the state of Green, is a physician licensed to practice in both Green and the neighboring state of Red. Doctor finds that the most convenient place to treat her patients who need hospital care is in the publicly owned and operated Redville Municipal Hospital of the city of Redville in the state of Red, which is located just across the state line from Greenville. For many years, Doctor had successfully treated her patients in that hospital. Early this year, she was notified that she could no longer treat patients in the Redville Hospital because she was not a resident of Red. And a newly adopted rule of Redville Municipal Hospital, which was adopted in conformance with all required procedures, stated that every physician who practices in that hospital must be a resident of the state of Red. Which of the following constitutional provisions would be most helpful to Doctor in an action to challenge her exclusion from the Redville Hospital solely on the basis of this hospital rule? A, the Bill of Attainder Clause. B, the Privileges and Immunities Clause of Article 4. C, the Due Process Clause of the 14th Amendment. Or D, Ex Post Facto Clause. Take a few seconds and choose the best answer now. I hope you chose option B, the Privileges and Immunities Clause of Article 4. No state may discriminate against non-residents with respect to privileges and immunities. A state, local law that does in fact discriminate against out-of-staters with respect to civil liberties or commercial activities violates the Privileges and Immunities Clause of Article 4 unless that state or local law is in fact actually necessary to achieve an important governmental purpose. Here, Redville Municipal Hospital is publicly owned and operated, so it qualifies as a state agency. The Redville Hospital adopted a rule requiring that every physician who practices in that hospital must be a resident of Red. In accordance with this rule, Doctor was no longer allowed to treat patients in the Redville Hospital. This rule, in essence, discriminates against out-of-staters, such as Doctor, with respect to her ability to practice medicine and, in fact, then earn a living. The facts do not indicate any important governmental purpose to justify this discrimination. Therefore, the Privileges and Immunities Clause of Article 4 is the most helpful constitutional provision for a doctor in an action to challenge her exclusion from the Redville Hospital solely on the basis of this hospital rule. Now let's analyze the other options and see why they're likely incorrect. A Bill of Attainder Clause, not especially relevant. A Bill of Attainder generally is a declaration or some sort of decree which makes a group of people guilty of committing something already. That being said, not especially relevant here. There's been no violation of such that was created. Ultimately, the doctor was just simply not permitted to practice. C, Due Process Clause of the 14th Amendment. The Due Process Clause applies to state actors, which arguably the hospital could be. That being said, it's generally more civil rights than anything else. Here, there is no allegation of a civil rights violation. There's only more specifically what would seem to be a Privileges and Immunities Clause violation. D, Ex Post Facto Clause. Not especially relevant. Sure, in essence, there was something that was created, i.e. a rule, which then subsequently made it improper to do some activity. But that being said, not really to the heart of what's intended by an ex post facto clause violation. Ultimately, this would be more like you are 25 years old and you're dating a 21-year or 20-year-old, and the law now converts the age of majority from 18 to 21. Now, that being said, if any activity that happened in the past would arguably fall into an ex post facto clause, because it would not have been illegal at the time that you were dating this 20-year-old. But it is now. So going back in time and criminalizing that behavior would ultimately be inappropriate. That's not what's happening here. We're talking about future issues. There was no issue in the past. There is no temporal issue here. So as a result, D is not correct, and B would be your very best answer here. Question number 4. At defendant's trial for sale of drugs, the government called witness to testify, but witness refused to answer any questions about defendant and was held in contempt of court. The government then calls officer to testify that when witness was arrested for possession of drugs and offered leniency if he would identify his source, witness named defendant as his source. The testimony offered concerning witness's identification of defendant is A, admissible as a prior inconsistent statement by the witness, B, admissible as an identification of defendant by witness after having perceived him, C, inadmissible because it is hearsay, not within any exception, or D, inadmissible because witness was not confronted with the statement while on the stand. Take a few seconds and choose the best answer now. If you chose option C, you'd be correct. Inadmissible because it is hearsay, not within any exception. Remember that hearsay is an out-of-court statement offered for the truth of the matter asserted in that very statement. A prior inconsistent statement of a witness who testifies at trial is not hearsay if it was given under oath at trial or deposition, and it is admissible to prove truth of the facts in that statement. Here, the testimony offered is witness's statement after being arrested. The statement is being used to prove the truth of the matter asserted, i.e., that defendant was in fact the source of the contraband that he had in his possession. This is hearsay and is inadmissible as a result. It does not qualify as a prior inconsistent statement because the statement was not given under oath. Therefore, the testimony offered concerning witness's identification of defendant is inadmissible because it is hearsay, not within any exception. In that analysis, we've already looked at option A as to the inconsistent statement by a witness, so we know that's incorrect. B, admissible as an identification of defendant by witness after having perceived him. I don't even know what that means, to be honest with you. Admissible as an identification of defendant by witness after having perceived him. So it's an admission as an identification because you saw him. That makes no legal sense and has no real basis. So let's eliminate that right off the bat. Now, this is a common theme. Many of the multiple choice questions, you'll have an option as an answer, which literally seems made up. Now, we are, again, dealing with model rules for the most part, but here and there will be these gems which are absolutely out of left field, and you should eliminate right off the bat. D, inadmissible because witness was not confronted with the statement while on the stand. Now, that actually, in essence, now it's accurate in that this would be inadmissible, but it's inaccurate as to why it would be inadmissible. Because witness was not confronted with the statement while on the stand. That's not the actual reason. The reason here is because it simply does not meet any of the hearsay exceptions. The fact that the witness was not confronted with the information is not relevant. The witness actually took the stand and refused to testify. So the witness said no actual words based on the call of this question. So that being said, there's actually, in fact, nothing to cross-examine them about. Question number 5. By warranty deed, Marta conveyed Blackacre to Beth and Christine as joint tenants with right of survivorship. Beth and Christine are not related. Beth conveyed all her interests to Eugenio by warranty deed and subsequently died intestate. Thereafter, Christine conveyed to Darren by warranty deed. There is no applicable statute, and the jurisdiction recognizes the common law joint tenancy. Title to Blackacre is in A. Darren, B. Marta, C. Darren and Eugenio, or D. Darren and the heirs of Beth. Choose what you believe is the best answer now. Well, I hope you chose option C, Darren and Eugenio. The rule is that a joint tenant may sell or transfer their interest in a joint tenancy during their lifetime without the knowledge or the consent of the other joint tenant. An inter vivos conveyance will sever the joint tenancy as to the conveying joint tenant's interest, and the buyer now becomes a tenant in common. In this case, Beth and Christine held Blackacre as joint tenants with the right of survivorship. Beth's inter vivos conveyance to Eugenio severed the joint tenancy, so Christine and Eugenio held Blackacre as tenants in common now. Christine then conveyed her interest in Blackacre to Darren, which resulted in Darren and Eugenio now holding title to Blackacre as tenants in common. So as a result, the correct answer is C. Question number 6. Athlete, a professional football player, signed a written consent for his team's physician, doctor, to perform a knee operation. After athlete was under a general anesthetic, doctor asked surgeon, a world-famous orthopedic surgeon, to perform the operation. Surgeon's skills were superior to doctors, and the operation was successful. In an action for battery by athlete against surgeon, athlete will A. prevail because athlete did not agree to allow surgeon to perform the operation. B. prevail because the consent form was in writing. C. not prevail because surgeon skills were superior to doctors. Or D. not prevail because the operation was successful. Choose your best answer now. If you chose option A, you'd be correct. Prevail because athlete did not agree to allow surgeon to perform the operation. A battery is the intentional infliction of a harmful or offensive contact with a victim's person. Harmful or offensive contact is determined according to an objective, reasonable person standard. In this case, athlete consented for his team's physician, doctor, to perform the knee operation. Athlete never consented for surgeon to perform the operation. A surgery is a very invasive procedure, and having an unconsented person perform the surgery offends a reasonable sense of personal dignity. Surgeon's superior skills or successful operation do not erase the fact that surgeon did not have athlete's consent to move forward and to perform the surgery. Therefore, athlete will prevail in an action for battery against surgeon because athlete did not agree to allow surgeon to perform the operation. Let's look at the other options, B through C. B prevailed because the consent form was in writing. This is an unclear response. The consent form to what was in writing? The consent form to have doctor? Sure, that's accurate. That could be accurate, but that is not necessarily the best answer, and A would trump without question. C, not prevail because surgeon skills were superior to doctor. It's irrelevant as to the skill of the practitioner. What is relevant is that there was a specific consent to have a specific individual. You cannot change that individual. D, not prevail because the operation was successful. Again, the success of the operation is irrelevant. It's the mere fact that the individual that conducted the surgery was not the person who was in fact granted authority to do so. So as a result, A is the correct answer. Let's move on to question number 7. Dawson was charged with felony murder because of his involvement in a bank robbery. The evidence at trial disclosed that Smith invited Dawson to go for a ride in his new car, and after a while asked Dawson to drive. As Smith and Dawson drove around town, Smith explained to Dawson that he planned to rob the bank and that he needed Dawson to drive the getaway car. Dawson agreed to drive to the bank and to wait outside while Smith went in to rob it. As they approached the bank, Dawson began to regret his agreement to help with the robbery. Once there, Smith got out of the car. As Smith went out of sight, Inside the bank, Dawson drove away and went home. Inside the bank, Smith killed a bank guard who tried to prevent him from leaving with the money. Smith ran outside and finding that his car and Dawson, in fact, were gone, ran down an alley. He was apprehended a few blocks away. Dawson later turned himself in after hearing on the radio that Smith had killed the guard. The jurisdiction has a death penalty that applies to felony murder. Consistent with the law and the Constitution, the jury may convict Dawson of A, felony murder and impose the death penalty. B, felony murder but not impose the death penalty. C, bank robbery only. Or D, no crime. Take a few seconds and think this one through. This one's going to possibly assume a bit of fact that's not included in the call of the question. The correct answer is B, felony murder, but not impose the death penalty. Under felony murder, the rule is that a person can be found guilty of a killing that occurs during the commission of an underlying felony that is inherently dangerous, such as burglary, arson, rape, robbery, or kidnapping. The death must have been a reasonable, foreseeable result of the felony. If one aids, abets, or facilitates the commission of a crime with the intent that that crime be committed, a person can be found guilty on accomplice liability theories, and the scope of liability includes liability for the intended crime and all other foreseeable crimes committed by the principals. Conspiracy is an agreement between two or more people to commit a crime. Each co-conspirator is liable for the crimes of all other co-conspirators if the crimes were reasonable, foreseeable, and committed in furtherance of the conspiracy. A party can negate their prior participation in the conspiracy with an affirmative act that notifies all co-conspirators with sufficient time for the other co-conspirators to have an opportunity to abandon the crime. The Supreme Court has further ruled that a defendant convicted for felony murder cannot be sentenced to death if they didn't take a life, attempt to take a life, or intended to take a life. So as a result, B would apply here because there wasn't sufficient notice of the abandonment of the crime, and as a result of the Supreme Court decision, the death penalty would not apply because the individual fled prior to the commission of any actual crime here by the part of the passenger. A, felony murder and impose the death penalty. That would be incorrect based on the Supreme Court decision. However, it is definitely arguable that many people might, if getting this one wrong, choose A, which is very close to the correct answer. C, bank robbery only. Well, that would be incorrect because he did not, in fact, abandon the crime prior to having given any notice to the other individual, and the other individual then subsequently went into the bank and committed a murder. So on a theory of accomplice liability, the client here would theoretically be liable on that accomplice liability. D, no crime. Clearly that's incorrect based on the prior analysis. Question number 8. In exchange for a valid and sufficient consideration, Goodbar orally promised Walker, who had no car and wanted a minivan, to pay to anyone from whom you buy a minivan within the next 6 months the full purchase price thereof. 2 months later, Walker bought a used minivan on credit from Minivanity Fair Inc. for about $8,000. At the time, Minivanity Fair was unaware of Goodbar's earlier promise to Walker, but learned of it shortly after the sale. Can Minivanity Fair enforce Goodbar's promise to Walker? A, yes, under the doctrine of promissory estoppel. B, yes, because Minivanity Fair is an intended beneficiary of the Goodbar-Walker contract. C, no, because Goodbar's promise to Walker is unenforceable under the suretyship clause of the statute of frauds. Or D, no, because Minivanity Fair was neither identified when Goodbar's promise was made nor aware of it when the minivan sale was made. Take a few seconds and choose the best answer now.